Is there a signal in here somewhere? A Wi-Fi signal? What is it? Is it the ISSA?
Well, good morning. I'm going to call this session of the City of Issaquah Hearing Examiner to order on May 31, 2017. We're here today because of an appeal filed by the Sammamish Heritage Society against the City of Issaquah regarding a threshold determination, or what's called a mitigated determination of non-significance. And what I'm going to do this morning is have a few introductory remarks, and then I've scheduled a pre-hearing conference where we're going off record. We're not going to record that, and anything that comes out of that we want to put on the record will then reconvene and go back on the record. I'm Ted Hunter of Sound Law Center, who your mayor and council has chosen to be the hearing officer on land use applications and certain appeals that are filed with the City of Issaquah. Many of you are in the room today. There's quite a room full of people. I do want to let you know that this is what's called an open record appeal hearing if we go to hearing. There are a number of threshold questions that I've circulated to the appellant and the applicant and the city that need to be addressed before we decide if I actually have jurisdiction to hold a hearing. If a hearing is held, it will be only those that have been identified as witnesses that can speak at that hearing and their representatives. This is not a public hearing where just anyone who appears has an opportunity to speak. And I'm sorry if any were misled by notice given by the city, but it is an open record appeal hearing where only those who have been identified as witnesses can testify at the hearing. Now, we'll have more about that if we actually go to hearing. I have some opening remarks I want to make. I have some notes in front of me I'm going to refer to, and this has to do with the background of how this appeal came before us today. I do want to let you know that the appeal was filed and timely filed with the city on May 1. And a date of today's date was set by the city, and my office was notified there would be a hearing on this date. Now, is the custom with setting the date, I did not know the nature of the proceeding. It wasn't until the 18th of May that we learned it was an appeal hearing. And it's a challenge when we have an appeal in order to get a pre-hearing order out to identify witnesses and documents. It is our custom and our experience that it helps to have a pre-hearing order to the attorneys of record in order to have all witnesses identified and all documents identified prior to the hearing. So what happened is on May 18th, when that was forwarded to my office, we saw for the first time the appeal and the MD&S that had been appealed. The next day, I did issue a pre-hearing order, and that set dates for submissions of motions and for disclosure of witnesses and documents. Now, following May 19th until yesterday, there was just a flurry of emails. Legal counsel, representatives of the different parties began sending emails, and some were directed straight to me. Some went to Mr. Niven, who's the planning director of the city. Some went to Candy Bear, who's the clerk to the hearing examiner. And there's so many, I stopped counting them. That is not how we proceed with an appeal hearing. Emails don't go around, emails don't go between two parties and then shared with the examiner. That is not the proper procedure. And at the end of my remarks, I'm going to set down some rules for how we move forward. It's no one's to blame. What's happened is the city has gone through a number of changes in their departments. We have had in the past, and I was notified today by Mr. Niven that she remains the clerk to the hearing examiner. Candy Bear is the clerk to the hearing examiner. All communication on appeals must be directed through her. You don't send stuff to me directly. You don't call my office and say, hey, I need to talk to you about the appeal. That is inappropriate conduct and contact, and we're not going to have any more of that going forward. I will note that in my pre-hearing order, again issued on May 19th, I had a date of May 24th for submission of motions. I extended that date because the appellant did have some challenges in receiving emails. Apparently, when we emailed the pre-hearing order, it went into a spam folder and they didn't see it until 2 days before the date motions were to be submitted. I extended that a bit that day to allow for submission of motions. No motions were submitted. I didn't get motions from the applicant's attorneys, none from the city, and none from the appellant. That's how we do an open record hearing. You submit motions. If you need a continuance, you submit a motion. You don't send an email saying, hey, I'd like to continue it, but I don't really tolerate more than a week. You don't do that. You submit a motion, you then contact the other parties and see what dates might be available for continuance. That did not happen. No motions were submitted. And that's a challenge because we have, as I indicated, a number of issues that we need to decide before we can even determine if we're going to hearing. Typically, that's done by motions. This is not a superior court, but we do follow an orderly procedure. And I'm really a little bit disturbed that that wasn't happening with the attorneys involved. You must follow the rules. We have rules of procedure. If you haven't obtained a copy, you need to get that from the city, from Candy Bear, the clerk to the hearing examiner, and we're going to follow the rules. Now, in May 22nd and 23rd, we did have the appellant, prior to them obtaining legal counsel, they did contact my office and noted that they had not received the pre-hearing order. We did allow an extension of motions, but no motions were filed. There were a number of emails about continuance, but there was no agreement on a continuance of a hearing date. There didn't seem to be any interaction amongst the parties about what dates might be appropriate. The applicant strongly objected to continuance and opposed that, but noted if one was given, it must be before June 7th, one additional week, and raising some concerns about violation of First Amendment rights if the hearing was continued past 1 week. This again is a challenge for the hearing examiner. If there's a concern about delay, there's ways to handle that with motions and indicating what is the nature of the concern. Frankly, I understand that the applicant might be a church, but we didn't have any legal grounds for not continuing it. However, there was an objection to the continuance. Therefore, on May 25th, I issued a second pre-hearing order, and it established that we would hold a pre-hearing conference today, and I would convene that in advance of the hearing. I knew that everyone had this date on their calendar, this date and time, and believe me, it's not easy to find a date and time where all attorneys can be present. So I stuck to this date and time, but now we'll hold a pre-hearing conference prior to going to hearing, if in fact we go to hearing. And I noted that if we can resolve the issues that I identified in that pre-hearing order, then the hearing would go forward. I know there was a lot of concern about witnesses. Again, the appeal was filed on May 1. The date was set by the city, apparently shortly after that, for May 31. It is known, or should be known by attorneys, that I do in every appeal hearing require disclosure of witnesses and documents prior to the hearing. Some responsibility rests with the parties. If you haven't received an order, then contact the city and find out what's going on with the appeal that you filed. That's appropriate to do. Contacting the city about the procedures is entirely appropriate. Now, the issues I noted in the second pre-hearing order are ones we're going to take up today off record with the attorneys involved to see if we can go forward with the hearing. And I wanted witnesses present for that reason, in case we go forward with the hearing. And even if we do not, I think there'll be an opportunity for the parties to discuss issues amongst themselves. And I want to note, too, on the date for filing witnesses and documents was May 26th. And I can read it, but you all have it, the attorneys for the parties themselves. The pre-hearing order gives very explicit instructions on how exhibits are to be filed. They're to be marked, they're to be tabbed, and that is so that we can proceed efficiently with the hearing. The city did that. The applicant and the appellant sent an email with attachments. Appellant gave me a pile of documents, And that makes it especially troublesome for my office to compile those documents and get ready for a hearing. So I'm going to set out some rules at the end of my opening remarks, and one of them is read the pre-hearing order and follow it. These have been developed over many years. We don't just put words in there that are unnecessary or are not to be followed. You need to follow the pre-hearing order. I don't take documents by email. I don't take documents that are in a stack without identification of what the exhibits are. That makes it very difficult to move forward in a hearing. If we do go into hearing today, it's going to take a lot more time. We're going to have each document submitted, identified, and determined if it can be admitted. You can avoid all that by following what's in the pre-hearing order. I also received phone calls, emails directly, emails from between two parties that then were CC'd to me about some kind of telephone conference. And everyone wanted to schedule that apparently for yesterday. Well, I need to share with you, I'm not a full-time hearing examiner at the City of Issaquah. I'm not just here at the city waiting for things to develop. I have a Schedule 2 and had prior hearings scheduled. There was no opportunity to do that. The opportunity is in the pre-hearing order to file motions and to get issues resolved prior to the hearing through the motion process. Well, that's the end of my sermon. I think I'll stop there. I've done enough preaching. My dad was a preacher, so I guess it comes naturally to me to do a little preaching. But what I do want to do is get this back on track. It's kind of gone off the pathway of what an open record appeal hearing should follow. I'm here to be the guide to try to get it back on track, and I think we can do that. The final thing I'm going to do on the record, and then we'll go off the record, is to give some rules for going forward. And then we'll move directly to the second pre-hearing order I issued and discuss the issues raised in that second pre-hearing order. So here's some rules for going forward. Please read all pre-hearing orders and strictly comply with them. An open record appeal hearing is like a trial before Superior Court. This is where you build the record. It's important to pay attention to all those orders. All material and all email correspondence, whatever, is to be submitted to the clerk to the hearing examiner. The clerk is identified in each one of my pre-hearing orders, and contact information for her is given. It's Candy Bear. I verified that this morning with the city. She remains the person for you to contact. That's where emails go. That's where telephone calls go. That's where documents go, not directly to my office. Please don't call my office directly. You know, as attorneys, that's not appropriate conduct. I'm not going to disclose every contact because there's so many of them. But ex parte contact typically would be disclosed. I can tell you that it was all procedural, thank goodness, but still, go through the clerk to the hearing examiner. And part of this is because of changes at the city. As I mentioned earlier, there has been a number of changes in that department, but we're going to get back on track with the one contact person. I ask, too, that you get the rules of procedure when you file an appeal and ask for those. I know attorneys are used to looking at the rules. They're like court rules. They have the same type of influence in how we hold an appeal hearing. So please obtain them, and don't wait. Inquire about the city about the status of the appeal. And finally, please comply with the orders that are issued. When I give dates, it's because we're trying to be fair to all. We give dates to file motions, dates to file witness list and documents to be fair to all. And if one ignores and then the others ignore because that first one ignored, you create chaos. So we try to comply with the dates. If there is some good reason you cannot, you ask for an extension. And typically extensions are granted if you have the consent of the other parties. There's only the applicant, the city, and the appellant. There's 3 parties involved in this hearing. It shouldn't be too hard to contact each other and get an agreement. And then any hearing officer, myself included, if it's said in a motion the parties have agreed that we want to extend the dates until thus and such, that can easily happen. My responsibility is to hold a hearing efficiently and fairly. I have a lot of directives on what constitutes fairness, and all of them look to constitutional principles and statutory principles of procedural due process. And that includes proper notice, it includes how we identify documents, and it includes how we proceed in an appeal hearing. That's my responsibility. I need the cooperation of all the parties, and especially those represented by legal counsel, which we now have in this room, legal counsel for all three parties. And with that cooperation and understanding that we are on the same team when it comes to fairness, we can move forward with an appeal hearing in a fair and efficient manner. So we're now going to go off the record. There's a lot of people here. I typically do not have a pre-hearing conference in front of a room full of people, but I think we need to do that. I'll ask the attorneys if they have any objection to that. But we're going to turn to my second pre-hearing order, the one that was issued with the list of issues that need to be addressed, and see where we go on those issues, and then we'll come back on the record once we determine if a hearing can be held today. Okay, so I ask that the record be stopped, and we'll begin discussion of the issues listed. All right, well, let's see what we can do as far as what we've agreed to in this pre-hearing conference. First, I think there is consensus. This is what I will state in my summation of the pre-hearing conference that will be issued along with the second pre-hearing order. First, that there's been no underlying project permit issued, and therefore there's been no appeal of an underlying project permit, and therefore the appeal hearing of an MD&S alone without consolidation with a permit appeal cannot go forward. Secondly, the city will issue a demolition permit today, and they'll condition that permit that there be no demolition action until there is a final decision on any administrative appeal to the city. Third, that demolition permit will contain a condition that will supersede the MD&S condition that requires that windows be preserved prior to demolition action. And then finally, that this hearing be continued until July 11th at 10 a.m., and I will issue a revised pre-hearing order setting out dates for identification of documents, witnesses, and resolution of any issues or filing of any motions. That'll go out later this week, and then we will see you back here July 11th, or maybe not. Maybe everything will be resolved. That's my hope, that you take action to do that. And we have this room for the balance of the morning, and so if you want to continue to meet in this room as legal counsel for the parties, you're welcome to do so. I'll again, thank you all that are here filling the room for being civil during this proceeding and quietly listening. Again, I need to remind you that this is an appeal, and it's fine to attend. In fact, we welcome your attendance and observation, but I don't want anyone to be misled. Even on July 11th, it's only those that are identified as witnesses that are allowed to testify at an appeal hearing. That being said, if we see you back here on July 11th, you're welcome to attend, and encourage you to do so. I think we've accomplished everything we can today, so now I'm going to adjourn this proceeding. Thank you all.
Thank you.